Injuries at work. We've talked about them here on this legal video blog in the past. We've talked about workers' compensation claims. But if you have a workers' compensation claim, can you also sue your employer in civil law? Well, that brings us to this week's case. It involves a woman married to a man. Unfortunately, he was killed in a trucking accident. He was a truck driver. Turns out there were two people who were actually employing him. The trucking company and also a company that owned the truck. Apparently the trucking company leased the truck from another company. Well, his wife, his widow, brought claim in workers' compensation against both of these two companies, the trucking company and the company that actually owned the truck. Turned out the company that owned the truck did not have any workers' compensation insurance. Notwithstanding that, she brought a claim against both of them. When it went forward, it was found that the transportation company was also a statutory employer of the man who died, and that a work comp claim could be brought against it, as well as the truck owner. After that was decided, she then also sued in civil law the trucking company, the company that owned the truck. Now, what's the difference here? In workers' compensation, if it arises out of and in the course and scope of employment, you can bring claim. So you get hurt, you bring claim. Insurance company steps forward, pays medical expenses, and also pays a portion of your lost income. Not all of it, a portion of it. It's a no-fault system. All you have to do is show that you were injured in the course and scope of your employment. That's what was done here. But anytime an injury is inflicted as a result of someone else's fault, that person who was at fault, that company who was at fault, also has an obligation to reimburse the person for all of their medical expenses, lost earnings, and all the other kinds of hassle, including pain and suffering that they have. You don't get pain and suffering in a workers' compensation claim. So, widow of the man who died brought claim against the truck-owning company and said, you guys owe me in civil law. You owe me for all those expenses, plus you owe me for pain and suffering, grief that I've had over the loss of my husband's life. Well, that truck-owning company jumped up and said, you can't sue us, because you brought a workers' compensation claim against us. Even though we didn't have workers' compensation insurance, you brought a workers' compensation claim against us, and therefore you elected remedies. You chose whether to bring a work comp claim or a civil claim. Since you chose to bring a work comp claim, you can't bring a civil claim. Okay. Well, in most states, and this case arose in Missouri, in most states you have one of two claims you can bring. You can either bring, if you've suffered injury in the course and scope of employment, a claim under workers' compensation, or you can bring a claim that is civil in nature against an employer. Some states don't give you an option. States like California don't give an option. You only get a workers' compensation claim. Other states do give you that option, but once you choose, you're stuck with your choice. So I went forward in the state of Missouri, went up to the Missouri Supreme Court, and there they said, well, you know what? The truck-owning company was without workers' compensation. Therefore, you can sue them, because in Missouri, if you don't have workers' compensation, someone can sue you under normal civil law and collect all of the damages that they have, including pain and suffering, loss of consortium, various kinds of things that this woman had suffered. And in this instance, since they didn't have insurance, the law in Missouri allows the injured party, in this case the widow, to bring that claim. And in this instance, even though she did initially bring a workers' compensation claim against them, she can still bring a claim in civil law against them. Why? Because they did not have workers' compensation insurance. So she was able to do that. Now, if she's successful in that claim, the company that paid under workers' compensation, paid the medical expenses and various funeral expenses, etc., will be able to get back the money they paid from any award she gets in the civil action. So what did we learn from this? We learned a lot of stuff. And one of the things that we did learn is that generally in all states, you have an election of remedies. And if you have a work comp claim, you can either sue your employer in civil law or you can bring a work comp claim. But in some states, you don't get that choice and you can only bring a workers' compensation claim. And there's a big difference between what you can recover in workers' compensation and what you can recover in civil law. In workers' compensation, they are all statutory recoveries that are limited by what the law provides. You only get a percentage of your lost income. You do get your medical expenses and you get a couple of other benefits. But under civil law, you get all of your lost income. All of your lost income. You get your medical expenses. You also get pain and suffering, and in some instances, other damages, as they're called under the law. So most people would like to bring that claim under civil law. Okay, we bring you this legal video blog as we bring you legal video blogs every week so you understand how the law works. I'm David Allen.